Good morning, my name is Kelly McKeon, and today I have the pleasure of interviewing David Pels. Today is November 13th, 2013, and I'm conducting this interview as part of the Connecticut Bar Foundation's James W. Cooper Fellows' History of Legal Services in Connecticut project. So David, do you want to just give us a brief timeline of how you came here and how long you've been here, what offices you've been in, and primarily what type of work you've done while you've been here?
Sure. I got out of law school in 1974, and for a couple of summers before I got out of law school, I worked at Neighborhood Legal Services in Hartford. It's an organization that was set up to receive Legal Services Corporation funding when that first started around 1970. And after I graduated, I worked for a while for Neighborhood Legal Services, and I went to Waterbury. Waterbury was then Waterbury Legal Aid and Reference Service. It was an independent organization that not only provided legal assistance, but also acted as the local bar's reference service. So we referred cases to the private bar. While I was in Waterbury, all of the programs outside of New Haven and Hartford merged into what became Connecticut Legal Services. And I moved to the New Britain office of Connecticut Legal Services, primarily because the housing court system was starting as a pilot project in Hartford and New Britain.
And was that what you were interested in primarily?
That's what I'd been doing in Waterbury.
Okay.
Was landlord-tenant work.
Okay.
So very shortly after the housing court started in New Britain, I went there.
Okay.
And then I went back to Neighborhood Legal Services. Neighborhood Legal Services closed in 1997 because there were actually two programs in Hartford, the Legal Aid Society of Hartford and Neighborhood Legal Services, and there was pressure from funders to just fund one Hartford organization rather than two. And then those of us who were left at Neighborhood Legal Services came over to what is now Greater Hartford Legal Aid.
Right. So was there some sort of how did you find out originally when you came out of law school about this program, and how did you actually get started? You know, did you know someone that had worked there, or?
I took a civil procedure course in law school, and my instructor was Bill Breitz, who had worked in Neighborhood Legal Services, and I think he had mentioned the organization.
Okay, so that's how you got interested. And what type of work have you primarily done?
It's been primarily landlord-tenant.
Okay.
Although before the merger, which created Connecticut Legal Services, most of the programs, including Waterbury, were doing a wide variety of work, and people were really generalists rather than specialists. So they would take almost any kind of civil case that walked in the door.
Okay.
So one of the cases I did in Waterbury was a jury trial of a malicious prosecution case, something which we would never do today.
Right. Okay. So how has your work changed over the years, would you say?
How has the work changed? Well, specialization has been a big change.
Okay.
Allowing people to concentrate on the core areas of legal aid.
So do you specialize now in mostly housing stuff?
Yes.
Okay.
So it's mostly landlord-tenant. Technology has been a huge change.
Mm-hmm.
Allowing people to become connected with not just folks in Connecticut
Mm-hmm.
doing legal services work, but also nationally.
Okay.
So information that might have taken weeks and several trips to the law library to gather, you can get almost instantly.
Right, right. Who are some of your mentors or colleagues that really had an influence on you over the years working for legal services?
Well, I mean, one of the first people who did housing work for legal services was Frank Deneen in New Haven. He's been doing it for a long, long time and is still doing it. I think he splits his time now between New Haven and Yale Law School.
Yep.
I mean, the first person I worked for in Neighborhood Legal Services was Mitch Perlman, who became the first executive director of the Freedom of Information Commission.
Okay. Do you want to talk to us a little bit about any of your clients in particular, or any cases that really stand out to you that really had an impact on you or had an impact on legal services in Connecticut generally? And any clients in particular, any stories that really stand out to you?
All right. I mean, there were two cases that Judge Maloney, now deceased, decided while I was at Neighborhood Legal Services in 1985, actually within a couple of weeks of each other. One was a smoke detector case. There was an infamous pro se landlord named Stanley Tucker, who had gone to Yale Law, not Yale Law School, to Yale undergrad, who was terrorizing tenants in Hartford and Torrington where he had property.
It was well known.
He was very well known. He actually sued me personally.
Really?
Yes.
After this case?
It was after the case. His theory was the Stockholm Syndrome. I don't know whether you've heard of that, but there was a bank robbery in Stockholm that became a hostage situation. The hostages started identifying with the bank robbers.
Right.
And so his theory was that I had somehow convinced my clients to stop paying the rent to which he was entitled. Therefore, he was entitled to collect the rent from me.
Interesting theory.
Interesting theory. Courts did not agree.
I can imagine.
But one of the cases that we had with Mr. Tucker was a rent collection case. And shortly before that was brought, there was a fire in Hartford in which 3 people were killed. And there was a little story in the newspaper. The fire chief said, they really shouldn't have died because there should have been smoke detectors in the apartment, and those are required by law.
Right.
Well, I didn't know those were required by law. I don't think many people did. So when he sued Jose Lopez for back rent, I filed a defense that he had violated landlord's obligation under Connecticut law to comply with all health and safety codes.
Right.
And we had someone from the fire department who came in and testified to the perhaps true story about the person who's giving a smoke detector as a present for Christmas. And there's a fire, and the unwrapped, smoke detector goes off,
Right.
and the family is saved. So Judge Maloney ruled in a small claims case that no rent was due. He wrote a decision, which virtually never happens now in small claims cases.
Wow.
The decision got publicized. It got reported in the Connecticut Law Journal, which was highly unusual for a small claims case.
Right.
People started buying smoke detectors.
So you really think that obviously had a big influence then?
Right.
Right.
Right. And the second case was something that I had sort of kept in my back pocket for a while. There was a person that I worked with, Waterbury, who you may be interviewing at some point named Rafi Podolsky.
Yes, I will be.
Okay. So I actually took over Rafi's spot in Waterbury when he started doing legislative advocacy.
Okay.
One of the cases he had was a case called Brown versus Banking Center, where there had been a foreclosure by the bank, and the sheriff had turned up at the tenant's door with a writ of ejectment to put them out. Tenant having received absolutely no notice that there was a foreclosure case going on and that they may be subject to being put out, and it was a 24-hour notice to get out.
Wow.
Okay. That case never got fully litigated because the premises burned.
Okay.
Okay. So that same situation arose in Hartford. It was happening all over. It was a case called Height versus Field.
Were there actually statutes in place at that point in time that had notice
Well,
requirements? And they just weren't following them?
No.
Oh, okay. There was nothing.
There was no notice required.
No notice requirements. Okay.
Right. Okay. So we filed a case saying, remember due process?
Right.
You know,
Okay.
Notice, opportunity to be heard.
Mm-hmm.
And we filed an action for declaratory judgment against the sheriff. There were sheriffs then instead of marshals. Against the court clerk who issued the writ of ejectment, and against the bank.
Okay.
And Judge Maloney ruled that, yes, due process does require that tenants get notice and opportunity to be heard before they can be removed in a foreclosure case. And in this case, the tenants were not even named in the case. And the bank's theory had been basically that the tenant should be checking, a month-to-month tenant should be checking the land records every month to see if there's a list pendants filed on the property.
Right.
And the judge said, well, that's not a very reasonable requirement.
Of course. So was it just a reasonable time period? What was the...
No, they had to change the statute because of the statute, which is 4922, was declared unconstitutional.
Okay.
So they said, no, you if you want to put the tenant out after foreclosure, you got to name the tenant and give them an opportunity to appear in court, present any defenses they may have, and they now have some defenses because of some federal legislation related to the foreclosure crisis. And you just can't summarily get you rid of ejectment and toss them.
You might have said this, but when was this case decided?
1985.
Okay. So it's had a big impact moving forward after that.
Right.
Right. And so what was it like working with these clients in the foreclosure cases? Any stories in particular about actually the clients, coming and talking to you and that type of thing?
Well, I mean, the foreclosure case, I mean, they were just completely bewildered because it is not atypical in a foreclosure case that the tenant is continuing to pay the landlord. If the tenant somehow finds out about the foreclosure case, landlord may say, don't worry your pretty little head, I'm working this out with the bank, keep paying me.
Right.
Even though the landlord may have legally lost title.
Right. Okay. So what was the reaction of the private bar to legal aid and the reaction of the judiciary? Do you have any recollection of, was it sort of a hostile reaction or supportive reaction in the beginning? And if so, how did it change over time?
I would say, the reaction I saw was mixed.
Okay.
In Waterbury, we were performing a service for the private bar, and that we were doing these referrals for fee-generating cases. So there was a relationship between our office and the private bar that was generally good. But, before the creation of the housing court, you would go into, the GA court, the lowest level court, and the eviction case could have been squeezed in between, some minor criminal offenses, a paternity case, a youthful offender case.
Mm-hmm.
And judges had very little expertise. And,
Do you think the judges in the beginning were receptive to having legal aid and legal services attorneys before them, or do you think that that's changed over time? Have they become more receptive to that?
I think they've definitely become more receptive. I think judges in general would rather deal with an attorney than a pro se.
Right.
But, you certainly face the judge who would say, just got one question for you, counselor. Did she pay the rent?
Right. And what about other attorneys around the state? Do you think that they had respect for legal aid attorneys in the beginning, or do you think that that's grown over time?
I think it's generally grown over time.
Okay.
You still have some people who are very hostile.
Mm-hmm.
Because
Any in particular stories that you can recall where you found an attorney or someone was being sort of hostile or had a negative view or?
Well, there's certainly some attorneys to this day who will, say legal aid as an epithet.
Right. So what's what impact did funding and the program structure have on your work? And you can just talk a little bit about, the funding and how the program structure's changed over time.
Right. Well, the funding is always in flux. In the Reagan era, there was a concerted effort to zero out the Legal Services Corporation funding.
Right.
And that, has remained fairly static. When Neighborhood Legal Services folded around the same time, because of all the restrictions attached to the Legal Services Corporation funding, they created a separate organization just to take the legal services funding called Statewide Legal Services.
Right.
And the other organizations were forced, and it turned out to be a good thing, to look for other sources of funding, whether it was, United Way or funding now set up through the Connecticut Bar Foundation, the IELTA program. Part of the impetus for doing that was people seeing the writing on the wall that, Legal Services Corporation funding could disappear altogether. It certainly wasn't going to grow a lot.
Right. And so how have you seen the program structure change?
What do you mean by structure?
Because weren't there a number of different, there's been a big shrinkage in the number of offices around the state over time?
That's true. Legal Aid Society in Hartford at one point had an office in Bristol. When Neighborhood Legal Services first started, there were 2 or 3, small offices in Hartford.
Right.
And for a lot of reasons, programs decided that really wasn't sustainable. That it was much more efficient to have larger offices rather than, having just 1 or 2 attorneys, by themselves in a smaller office.
Right.
And having, more people together, I think makes the work better.
Right.
Because people, can, go next door and, talk about problems and try to solve them together.
Right. So what has been the impact on your legal career of your experiences working for legal services? So you've been here for how many years now?
When you say here,
working for...
I worked for legal services since I got out of law school,
right.
which is 1974.
Okay, so what, what impact has, all these experiences have on your life in general? I mean, have you enjoyed working for, legal services over the years? And why have you stayed here over the years?
Well, it's an opportunity to make an impact that you wouldn't necessarily have some other place.
For example, some people go to legal services for a couple of years and then they go into private practice or something like that. So how come you've stayed here over the years, since you got out of law school until now?
Because I enjoy the work. Private practice really didn't have any appeal for me.
Okay. That's fair.
And I didn't want to deal with the business end.
Okay. So you really like
being-
just working with the clients and not having to worry about
Right.
that stuff.
Mhm.
Okay, great. Anything else you'd like to tell us, or?
No, thank you for doing this.
Thank you.